Legal Eagle is coming in loud and clear thanks to Ting Mobile. Lying to the FBI is a federal crime. Now, imagine this scenario. You have lied to the FBI. Everyone knows that you lied because you admitted to lying twice in open court. You said, "Yes, Your Honor, I lied to the FBI." You sign a detailed statement admitting to the facts that you misrepresented. You agreed to never file a motion to withdraw your guilty plea. You signed a document allowing incriminating things you said in court to be used against you in future proceedings. And now it's time for you to be sentenced and ultimately to go to jail. And the prosecution, the lawyers who charged you with a crime, file a motion in court saying, in essence, hold on here, we no longer think we can prove beyond a reasonable doubt that this defendant lied to the FBI. So, Your Honor, we'd like to dismiss these charges. Now, in a situation like this, despite the prosecutor's change of heart, the judge has the final say over all of this. And since you agreed that you committed the crime and that your statements could be used against you, you perjured yourself to federal agents. After all, you admitted to it twice. So, you're going to jail, right? Well, if we're talking about you, dear Legal Eagle, I'm sorry to say yes, you are probably going to jail. But if you are friend of the President Michael Flynn, maybe not. Welcome to the latest episode of As the Department of Justice Turns. Oh, past Devin, you thought you were going to be able to release this video on Monday. I laugh, you handsome idiot. You have no idea of the crazy stuff that's going to happen throughout the rest of this week. It's got everything from corruption at the DOJ to whistleblowers at the FBI, crazy procedural stuff. So if at the end of this video it looks like I have bags under my eyes and I haven't gotten any sleep, it's because I have bags under my eyes and I haven't gotten any sleep because I've continually tried to revise this video to be up to speed with all of the crazy stuff that's happening. It's definitely worth your time. This is unprecedented in terms of what the DOJ is doing, what the judge is doing in response to that. So yeah, let's stick around. It's definitely worth your time. It's an insane story. And let's turn it back over to past Devin, you beautiful moron. If you're wondering what just happened to Michael Flynn and why the Department of Justice is attempting to drop the prosecution against him, and if they can even do that, I'm about to take a deep dive into the ironclad case against Flynn and the ins and outs of 18 U.S.C. Section 1001 and the big mess at the Department of Justice. Let's start with some background on Michael Flynn and how he found himself in this particular situation. Michael Flynn was only employed by the Trump administration for 24 days, but a lot happened during those 24 days. Flynn made many phone calls to foreign governments, particularly to Russia, and then lied to the FBI and particularly the Trump administration about those phone calls. This happened during a period when Flynn was already being investigated for working with the Russians. So just who is Lieutenant General Michael Flynn anyway? Well, before joining the Trump administration, Michael Flynn was a retired lieutenant general who held 2 intelligence posts with the federal government. Flynn was the director of the Defense Intelligence Agency under President Obama and served as the national security advisor to President Trump. While serving in the Obama administration, Flynn became the first American to visit the GRU in Moscow. The GRU is the successor to the KGB. Flynn retired from the DIA in 2015, a year earlier than expected, and the scuttlebutt is that Flynn's resignation was generally attributed to being a not great boss. But Flynn's stints in the intelligence world were marred by allegations of mishandling of sensitive information and potentially deception. When a government official serves in a position where they handle sensitive information, they are required to disclose all contacts with foreign nationals and governments. During Flynn's time as DIA chief, his activities raised alarms among some CIA and British intelligence officers. They claimed that Flynn concealed his relationship with a Russian-British graduate student, Svetlana Lakova, whom Flynn met on a trip to Cambridge in February of 2014. The two carried on an email correspondence with Flynn referring to himself as General Misha. Now, there's no proof that Lakova was a spy or a honey trap for Flynn, and in fact, she later filed a defamation lawsuit against the Wall Street Journal, the New York Times, the Washington Post, and MSNBC, amongst others. And this will be of interest to all of you Legal Eagles who watched my videos about defamation because her lawyer was none other than Stephen Biss, the same lawyer who represents Devin Nunes in many of his, what I think almost everyone agrees are frivolous defamation lawsuits against internet cows and other phantom menaces. Now, Lakova's case was dismissed. It was actually handled by a friend of mine, and I think this generally falls into what you would consider an anti-SLAPP suit. But one of the questions that tangentially I would like to have answered is, who is paying for Stephen Biss to file all of these crazy defamation lawsuits? If you happen to know the answer to that question, please send me an email, because I would very much like to know. At any rate, after Flynn's retirement from the armed services and from the intelligence community, he started a consulting business called the Flynn Intel Group. And in 2016, Flynn appeared at a conference whose participants discussed the coup attempt against Turkish dictator Recep Erdogan. And at the time, Flynn was on record for getting rid of Erdogan, who he believed was pushing Turkey away from secularism and toward radical Islam.
Really became a secular country, meaning a sort of a regular sort of nation state, and then began to move towards Islamism. This is Turkey.
You may recall that Erdogan was the one that a few years ago had his armed guards beat the crap out of a bunch of protesters here in DC. But as so often happens, Turkish business groups hired Flynn Intel Group and paid them lots of money, such that by 2016, Flynn was lobbying on Erdogan's behalf. And on election day in 2016, Flynn wrote an op-ed for The Hill explaining that the US needed to fully support Erdogan. And this was a particularly big deal because Flynn was the former head of the DIA and was close to the incoming president. But there was one big problem. Flynn had failed to disclose that he had been paid by Turkey for the consulting work when he wrote the op-ed. And The Hill amended the article saying that Flynn didn't tell them that his firm had received payments from a company with close ties to the Turkish government, nor did he tell them that the company had reviewed the draft of the op-ed before it was submitted. And on top of that, as a retired military intelligence officer, Flynn is required to obtain prior permission from the Defense Department and the State Department before receiving any money from foreign governments. However, after Flynn retired, he accepted $45,000 from Russia Today, an English language media outlet that is owned by the Russian government. Russia Today paid Flynn to attend a dinner in Moscow where he hung out with none other than Vladimir Putin and the Green Party's own Jill Stein. Now, Flynn also accepted money from Kremlin-linked companies for speaking engagements, but again, he didn't seek approval for any of this. And this is where FARA comes in for the first time. After it was clear that Flynn was deeply involved in promoting Erdogan's interest, this caught the attention of the Pentagon and other intelligence services around the world. It was clear that Flynn's secret work for foreign governments may have violated the Foreign Agents Registration Act, or FARA. FARA is a law that requires individuals who are representing political interests of foreign powers disclose their relationship with the foreign government and the information related to activities and finances. In other words, if you're working for foreign governments, the American public has a right to know about it. This is obviously particularly important where there are major policy differences between countries. And in this particular case, for the last 5 years, the United States and Turkey have disagreed over whether the US should extradite Fethullah Gulen, a Muslim cleric living in the mountains of eastern Pennsylvania. Gulen, who's 81, is the leader of a religious movement within Sunni Islam called Hizmet. Some say promote peace and civility, whereas Erdogan believes that Gulen is a terrorist who is behind efforts to remove him from power. Now, at the same time, a Turkish national named Bijan Rafikian was a partner in the Flynn Intel Group. Rafikian, Flynn, and others lobbied the US government to extradite Gulen to Turkey. And as it happens, Rafikian and a co-conspirator were later convicted in their role in plotting to covertly influence United States politicians and public opinion against Gulen. And as if this wasn't enough, Flynn and his son were allegedly offered $15 million to travel to the Poconos and kidnap Gulen and extradite him to Turkey. And a reminder why this is important, Flynn was frequently lobbying foreign governments without disclosing his activities or his pay arrangements. And it was around the same time that, despite this activity, or perhaps because of it, Donald Trump tapped Michael Flynn to be his national security advisor. Now, because of this, on August 16, 2016, the FBI opened up an investigation to find out whether Flynn was being controlled or influenced by Russia. He was being investigated for violating 18 U.S.C. 951, which makes it illegal to be a foreign agent. This investigation wound down by January 4, 2017, right before Donald Trump took office. The FBI was preparing to close this case. However, during the same period, the Obama administration was trying to understand why Russia had not responded to the additional sanctions that they had levied against Russia for hacking US elections. What they learned is that Flynn had actually been chatting with Russian Ambassador Kislyak. Now, there are some circumstances where you might want to talk to a foreign colleague for various reasons in a transition situation. But what the FBI found is that Flynn had been discussing the sanctions that had been levied against Russia by the Obama administration. And there are disputes about whether this conversation was about policy or not. not. But the context of this conversation was that if Russia indeed reacts against the Obama sanctions, then effectively the Trump administration is going to have to respond once it takes office. So the Trump administration didn't want to be in a hole against Russia and have to retaliate against it, which under any reasonable interpretation is a conversation about policy. Now, the case agent in charge argued that the Flynn investigation should remain open because of this particular information. Now, while the DOJ and the FBI tried to figure out what to do, Vice President Mike Pence suddenly and publicly said that, in fact, Flynn did not interfere with the Russians and did not have policy discussions about the sanctions. Allegedly, that's because Flynn lied to Mike Pence. Now, query whether Mike Pence knew about this information or not, but the party line is that Flynn lied to Pence. Pence went public with the lie and by proxy carried that misrepresentation forward to the American public.
I knew that he lied to me, and I know the president made the right decision with regard to him.
And at that point, the FBI decided to interview Flynn about whether he was working with the Russians or not. The interview wasn't about election interference per se, but it was in connection with the ongoing concern about Flynn's own actions. And eventually, Flynn agreed to have a voluntary conversation with the FBI. So in this context, let's talk about the crime of lying to the federal government. Under 18 U.S.C. 1001, it should surprise no one that it is a crime to lie to the federal government. Section 1001 makes it a crime to knowingly and willfully make any materially false, fictitious, or fraudulent statement or representation in any matter within the jurisdiction of the executive, legislative, or judicial branch of the United States. Now, to prove a violation of Section 1001, the prosecutor must prove the following 5 elements. Number 1, a statement or representation or document was made or used. 2, it was false, fictitious, or fraudulent. 3, it was material. 4, it was made or used knowingly and willfully. And 5, it was related to an action within the authority of the relevant federal agency. Now, the third element, that a statement was material, is often the most disputed issue in a Section 1001 case. Now, according to the DOJ's own handbook, the test for materiality under Section 1001 is not whether a false statement actually influenced a government employee or function, but whether it had the capacity to influence them. The ultimate issue, according to the DOJ, is that if a lie is an attempt to influence a decision maker, i.e. convince them of something, then it's material. It doesn't matter if the FBI already knows that you're lying or isn't convinced by your lie. That doesn't affect the materiality of the lie itself. In other words, it's not necessary to show that the particular lie ever really influenced anyone. And when the DOJ prosecuted Flynn, they argued and the judge found that his lies were in fact material. So let's talk about the things that Michael Flynn actually lied about. In order to plead guilty, Flynn had to agree to a detailed statement of the offense. Now, this document is not always a take it or leave it proposition from the prosecutors. In most cases, and certainly in this case, the defendant and lawyers pore over the language and negotiate with the prosecutors about precisely what the defendant is admitting to. So what did Flynn admit to lying about? Well, there are 3 categories of lies. First, lies regarding his communications with the Russian ambassador to the United States. Second, lies about his communications with Russia and other countries about Israel. And third, lies about his paid work for foreign governments. So let's talk about the first category of lies about Russia. The special counsel led by Robert Mueller was investigating Russia's role in 2016 election interference. Now, a key issue was whether the Trump campaign, through intermediaries, including Michael Cohen and Michael Flynn, family members like Jared Kushner and Don Jr., and campaign staff like Paul Manafort, discussed the possibility of lifting U.S. sanctions on Russia in exchange for help in the 2016 election. After President Trump was elected, but before he was sworn in, the U.S. government implemented additional sanctions on Russia. Mueller reported that people close to Trump indeed tried to undermine U.S. sanctions before Trump was inaugurated. Now, according to Flynn's statement of the offense on January 24, 2017, Flynn voluntarily agreed to an interview with FBI agents. He wasn't coerced into having this interview. He voluntarily agreed to talk with FBI agents. Now, during this interview, Flynn said that he did not ask Russia's ambassador to refrain from responding to the new Obama sanctions against Russia. And he also said that he, quote, did not remember a follow-up conversation where the Russian ambassador said that Russia had chosen to moderate its response because specifically of its communications with Flynn. Now, those statements were unequivocally false. Flynn admitted that on the same day that President Obama had signed an executive order imposing sanctions against Russia for its interference in the 2016 presidential election, the Russian ambassador called Flynn, and when Flynn said he didn't remember the conversation, that was a lie. And there were additional phone calls between Flynn, the Trump transition team, and Kislyak. Flynn admitted that after he phoned Trump's people at Mar-a-Lago, he then called Ambassador Kislyak to ask that Russia not escalate the situation and only respond to the US sanctions in a reciprocal manner. Flynn then reported back to the group hunkered down at Mar-a-Lago. Flynn spoke with Kislyak again on December 31st when they discussed Russia's intention not to retaliate in response to US sanctions because of Flynn's request. And once again, Flynn called senior members of the presidential transition team to tell them that Russia wasn't going to retaliate. Now, why does all of this matter? Why are these lies material? Because Flynn was communicating with Russia, a foreign adversary, that they didn't need to retaliate against President Obama's sanctions, leading to an inference that he was telling them that President Trump would get rid of the sanctions as soon as he was in a position to do so. It's also a signal that President Trump didn't care that Russia, according to intelligence agencies in the US, interfered in the US election. And perhaps most importantly and most shockingly, the Russians, of course, knew at all times what had and had not been discussed with Michael Flynn. And they knew what policy might and might not be on the table. They knew what potential policy changes were going to happen with the Trump administration. And worst of all, they had caught Michael Flynn in a lie. They knew that Michael Flynn had lied to Vice President Mike Pence and to the American people. So they now had leverage against the National Security Advisor to the United States. They knew that he had lied to the American people. That's really bad. Apart from all of the legal issues in Section 1001 or FARA, that's basically a worst-case scenario from a counterintelligence perspective. On top of that, there were lies about a UN resolution. Michael Flynn admitted to making false statements about a UN Security Council resolution condemning Israeli settlements. Flynn claimed that he did not request that any of the countries take any particular action on the resolution, but in his statement of the offense, Flynn acknowledged that the statement was false. He really did contact the countries to try and influence their vote in the UN. And then there's the third category of lies about paid work for foreign governments. When Michael Flynn took the job with President Trump, he made false statements about what the Flynn Intel Group had been up to, specifically his activities, quote, for the principal benefit of the Republic of Turkey. Flynn made, quote, materially false statements and omissions, end quote, including hiding that the government of Turkey was directing his activities. Although Mueller did not formally charge Flynn with violating FARA, he did include admissions in the statement of offense, and Flynn has pled guilty to those offenses. So that takes us to Flynn's guilty plea. So why did Flynn plead guilty? Well, as with most criminals, it's because cooperation gets you a lighter sentence, and sometimes being charged with only a small fraction of the offenses that ultimately could have come down the pike. And Flynn decided to cooperate fully with the special counsel's investigation. He participated in 19 interviews with the special counsel's office, and the extensive cooperation convinced Robert Mueller to recommend a relatively light sentence. And back in December 2017, Flynn appeared in court to enter his guilty plea. He did not object to the prosecutor's description of his lies to the FBI, and Flynn admitted that he had violated the law. The judge asked, "Are you entering this plea of guilty because you are guilty and for no other reason?" To which Flynn replied, "Yes, Your Honor." He reaffirmed his plea at another hearing on December 18th, 2018, 1 year after his first appearance, and he said that he was satisfied with his lawyer's representations, did not want a second opinion about pleading guilty, and did not want to withdraw his plea in light of certain FBI agents being investigated for misconduct, and that he knew lying to the FBI was a federal crime. As part of that plea, Flynn agreed not to file a motion to withdraw his guilty plea. And although generally Federal Rule of Evidence 410 prohibits the use of guilty plea statements to incriminate a defendant in later proceedings, Flynn explicitly waived Rule 410 in his guilty plea. But by January of 2020, Flynn had new lawyers. He had attempted to withdraw his plea and claimed that all of his earlier admissions were actually lies, and was asserting that he in fact never lied to the FBI. Now, that's not to say that Flynn's prosecution has been completely without issue. Flynn has long complained that he was being railroaded by the deep state, and he had long complained that his lawyers had a conflict of interest and provided ineffective counsel. And that had largely been an issue in terms of trying to undo his guilty plea. He obviously had pleaded guilty several times and was trying to be able to withdraw that plea. Now, through most of this ordeal, Flynn was represented by a firm called Covington & Burling, a huge U.S. firm, white shoe, well known for being politically connected and one of the biggest and most well-respected firms in the country. Flynn dropped Covington and Burling for the aforementioned reasons last year and signed with another very well-known attorney named Sidney Powell. Interestingly, in April of 2020 of this year, Covington and Burling revealed that they had recently uncovered emails and handwritten notes that they claimed were inadvertently left out of a trove of records that they turned over to Flynn's new lawyer, Sidney Powell. Now, it's hard to opine on the claims of ineffectiveness of counsel without knowing more about the representation here. Ineffectiveness of counsel is generally a defense that applies to the indigent, not a political appointee with one of the biggest firms in the country. That said, it's pretty unusual to have to turn over documents long after you have been fired by a client and have that client retain another lawyer. I mean, it's not a good look to have potentially relevant documents that the new attorney needs to review and to see. That being said, Covington and Burling had these documents throughout their representation of Flynn, so it's a very hard burden to show that failing to turn over these documents to the new lawyer is going to have prejudiced the prior representation. He's got a very steep uphill climb to make there. Which takes us to the actions of the Department of Justice under the guidance of Attorney General Bill Barr. Now, with Flynn about to be sentenced, there was speculation that President Trump would actually pardon him for his crimes. But it appears that instead, Bill Barr took action. First, in January 2020, Barr appointed a U.S. Attorney Jeffrey Jensen to review Flynn's prosecution. This was unusual, especially since Flynn was about to be sentenced and Jensen had never reviewed any of the prosecutions that came from the special counsel's investigation. And query why we have a special counsel at all if the actions of the special counsel can simply be reviewed and undone by later attorneys general. You can see that there might be a problem if you fire the attorney general and then appoint an attorney general who's just going to undo the supposedly independent investigations of the special counsel's office. We'll talk about that later. By the time that Jensen was brought on to review the case, the judge already ruled that there was no reason to dismiss the case. But in a brand new motion, the DOJ now claims that it was totally inappropriate for the FBI to question Flynn in the first place, and they're trying to dismiss the claims against him despite his multiple guilty pleas and being on the eve of sentencing. And to sum that up, Flynn was investigated for being a Russian agent. He had secretly talked to Russia about undermining U.S. sanctions. He had lied to Mike Pence about his involvement, and whether that's legal or not, it was the reason that Donald Trump gave for firing Flynn in the first place, or at least leading to Flynn's resignation, and he had a long history of hiding his involvement with foreign governments. Yet, unbelievably, the DOJ is now saying that none of that was a good enough reason for the FBI to interview Flynn, and that those representations were not material to that investigation. And recall that the special counsel's office had a dual mandate. They were both to investigate the counterintelligence issues at hand and also any criminal liability that might attach to the Russian hacking and interfering with the U.S. government. Now, the only attorney to sign the DOJ's motion to dismiss was newly appointed U.S. Attorney Timothy Shea. He's the head of the U.S. Attorney's Office in the District of Columbia, and thus he is one of the top 3 most powerful prosecutors in the country. The other 2 being the Southern District of New York and arguably the Eastern District of Virginia. Potentially, the U.S. Attorney's Office for the District of D.C. is the most powerful office. Depends on who you ask. And it's important to note that Shea, who is a longtime colleague of Bill Barr, replaces outgoing U.S. Attorney Jessie Liu, who left the post at the U.S. Attorney's Office for D.C. to take up an appointed position with the Treasury Department. But just a few months ago, the Trump administration inexplicably just removed her nomination entirely, so she was effectively fired from her past job. And the Department of Justice, through Timothy Shea, is arguing in this motion to dismiss that the government had already decided not to charge Flynn under FARA, so the decision to interview him by the FBI was illegitimate. Now, the DOJ had not officially written a memo closing the file, but Shea portrays the closure of the investigation as a mere formality. He went even further by exonerating Flynn entirely, stating that his chats with Kislyak were totally fine. And the DOJ's brand new position is that, quote, there was no factual basis for the predication of a new counterintelligence investigation, nor was there a justification or need to interview Mr. Flynn as to his own personal recollections of what had been said. The DOJ motion relies heavily on an interview with former DOJ lawyer Mary McCord. This 2017 interview with McCord about the circumstances of the Flynn investigation was cited more than 25 times in the motion. However, Mary McCord wrote an editorial just a few days ago slamming her former employer, the DOJ, for twisting her own words. Now, although Mary McCord is no longer with the Department of Justice, she was an incredibly high-ranking official at the time of the Flynn investigation. She was in fact the Deputy Attorney General in charge of national security. According to McCord, her interview merely describes a, quote, difference of opinion about what to do with the information that Flynn apparently had lied to incoming Vice President Mike Pence, and whether Flynn's lies should be shared with President-elect Trump, not as to whether the investigation should proceed in the first place. McCord states that the debate was a completely different topic that had nothing to do with the legitimacy of interviewing Flynn. Quote, the report of my interview is no support for Mr. Barr's dismissal of the Flynn case. It does not suggest that the FBI had no counterintelligence reason for investigating Mr. Flynn. It does not suggest that the FBI's interview of Mr. Flynn, which led to the false statements charge, was unlawful or unjustified. McCord said that Flynn's lies were material to a counterintelligence threat because his lies exposed him to the threat of blackmail. And McCord implies that the DOJ's new arguments are misleading because they ignore that the investigation was into whether Flynn had violated 18 U.S.C. 1951. In other words, whether he was actually working with Russia or not. The official investigation was not closed because the FBI learned about Flynn's conversations with Kislyak and sought more information. I'm not an FBI agent, but it doesn't seem unreasonable for the FBI to hold off on closing the file in order to question someone who might be spying for a foreign country. And DOJ prosecutors originally told the court that Flynn's lies were material and that any attempt to undermine the sanctions could be evidence of collusion between Russia and the Trump campaign. Whether that ultimately proved to be true or not doesn't mean that you can just get away with lying to the FBI with impunity. Again, it doesn't matter if the FBI believed what you were saying at the time in order for the lies to be material. But in the motion that was filed last week, the DOJ reversed itself and ignored the judge's prior ruling in order to claim that things have simply changed. The DOJ hasn't really told the court what that change is. It's just changing its position. And Tim Shea also argued that the case should be dropped since the government can't prove Flynn lied beyond a reasonable doubt. This is particularly peculiar given the number of times that Flynn has already pled guilty to the matter itself. There's really no question that he lied. It's only a question of whether that was material or not. Now, Shea's motion also claims that it's based on new information, but McCord confirms that the DOJ had access to all this information the whole time. And speaking of which, one of the high-ranking FBI agents has also come forward claiming that the Barr-led DOJ interviewed him about his actions and notes surrounding the Flynn interview and failed to apprise the court of his testimony and evidence, which he claims was counter to the DOJ's narrative in the Shea motion to dismiss. Apparently, in preparation for this motion to dismiss, the DOJ interviewed Bill Priestap, who was the former head of FBI counterintelligence, 2 days before making their extraordinary request to drop the case in front of Judge Sullivan. Now, apparently they didn't tell Judge Sullivan about Mr. Priestap's interview. And that's a bad look because generally lawyers have a duty to present negative evidence or negative authority to a judge. You don't have to give it the light most favoring the other side, but you do have to at least acknowledge that it exists. And the New York Times reports that the DOJ is claiming that they're in the process of writing up a report of the Priestap interview and will in fact file that with the court. We'll see if that happens. Now, Priestap apparently says that the FBI was never trying to lay a perjury trap and claims that FBI officials were trying to do the right thing in questioning Mr. Flynn and knew of no effort to set him up. Media reports to the contrary. Meanwhile, not everyone at the Department of Justice is just sitting idly by. Brandon von Grack, who heads a unit responsible for prosecuting violations of FARA, withdrew from the case and from 2 others where Flynn is a party. This tends to be what happens when a lawyer does not stand behind the pleading that his boss wants him to file. We saw that in the Roger Stone sentencing case where 4 U.S. attorneys withdrew from the case because of what appeared to be improper interference by AG Barr. And although the Attorney General is a political appointee, the DOJ's overall law enforcement goals shouldn't be partisan. The vast majority of people who work at the FBI and the DOJ will spend their careers working for both Republican and Democratic administrations. This doesn't mean that they aren't entitled to political opinions, but their opinions aren't germane to their investigations, and it shouldn't interfere whether they decide to prosecute someone or not, or give special treatment to other people in government. And in fact, former DOJ lawyer Jonathan Kravis wrote an editorial for the Washington Post revealing that he left the DOJ because of similar machinations involving the Roger Stone investigation. Kravis was especially offended by Barr's earlier comments criticizing prosecutors for their actions. And as Kravis points out, career prosecutors and FBI agents aren't allowed to comment publicly about criminal investigations, nor can they respond to their boss, AG Barr. Kravis wrote, "Department lawyers are ethically bound to protect the confidences of their client, the US government. Barr's decision to excuse himself from these obligations and attack his own silenced employees is alarming. It sends an unmistakable message to prosecutors and agents. If the president demands, we will throw you under the bus." And Kravis is not alone. More than 2,000 former Department of Justice employees agree. They published a statement condemning Barr and calling for his resignation, stating, "The department's action is extraordinarily rare, if not unprecedented. If any of us or anyone reading this statement who is not a friend of the president were to lie to federal investigators in the course of a properly predicated counterintelligence investigation and admit we did so under oath, we would be prosecuted for it." They go on to say that we thus unequivocally support the decision of the career prosecutor who withdrew from the Flynn case, just as we supported the prosecutors who withdrew from the Stone case. They are upholding the oath that we all took, and we call on their colleagues to continue to follow their example. Like Kravis, these ex-employees are also extremely concerned about retaliation by Barr and Trump. Quote, "President Trump accused the career investigators and prosecutors involved in the Flynn case of treason and threatened that they should pay a big price. It is incumbent upon the other branches of government to protect from retaliation these public servants and any others who are targeted for seeking to uphold their oaths of office and pursue justice." Kravis is just as skeptical of claims that the DOJ is acting in good faith. Quote, "If the department truly acted because of good faith commitments to legal positions, then where is the evidence of those commitments in other cases that do not involve friends of the president? Where are the narcotics cases in which the department has filed a sentencing memorandum overruling career prosecutors? Where are the other false statements cases dismissed after a guilty plea?" Speaking for myself, if we want to have a conversation about criminal justice reform and curtailing some of the FBI's power or their ability to use the broad mandate of Section 1001 so that we can talk about a more fair justice system, I'm all for that. I and a whole bunch of other defense lawyers would love to be able to remove some of the power that the federal government or other investigators have when investigating people. But this isn't one of those cases. This isn't a case of reforming the underlying law. It's a case of special treatment doled out to one of the president's closest advisors. That is the exact opposite of the rule of law. That's crony capitalism. It's corruption. So many people who had no frame of reference lashed out at some of the tactics that the FBI used in this particular case and were appalled. But the truth is, the FBI has done similar things in thousands, if not hundreds of thousands of other cases. You want to have a conversation about reforming some of those actions? Fine. I'm all for it. But the Michael Flynn case is not the venue for criminal justice reform. It's just simply special favors being doled out to friends of the president, the opposite of the rule of law. Flynn had every advantage. He was at the highest echelons of government. He had the best lawyers, and he spoke to the FBI voluntarily of his own accord on advice of counsel. He wasn't railroaded. He wasn't entrapped by the government. You want to talk about criminal justice reform? Let's do it. This is not that case. So let's talk about what's going to happen next and the judge's role. Judge Sullivan is the presiding judge, and the government has asked Judge Sullivan, in Flynn's case, to drop the prosecution entirely. Sullivan is not required to do so. Under Rule 48A of the Federal Rules of Criminal Procedure, a government motion to dismiss an indictment even after a guilty plea requires what's called leave of court, so the judge gets to decide. Judge Sullivan probably will grant the leave to dismiss because there won't be an opposing party. Both the government and Flynn are going to argue in favor of dismissal. But Judge Sullivan does have the discretion to deny it and just go straight to sentencing. And it's significant that Flynn pled guilty twice, and that Judge Sullivan ruled Flynn's lies were material to an investigation, and that he has already received sentencing memoranda from both sides. But we don't really know what Judge Sullivan will do. He's known as a mercurial judge, and he will go his own way. Okay, so fast forward a couple of days, and here's where things really start to get crazy in terms of the prosecution of Michael Flynn and particularly Judge Sullivan. So in reaction to this effectively unprecedented motion by the Department of Justice, Judge Sullivan started making some moves. The first thing that he did a couple of days ago was that he issued a minute order, which is usually just a short order that appears on Pacer, have a huge document associated with it, in which he asked for third parties to write what's called an amicus brief. An amicus brief is a brief filed by a third party that has no stake in the case itself. It's an amicus brief filed by an amicus curiae. And this is very, very normal in an appeals context, where appeals cases have far-reaching implications. They set precedent, and so it's not unusual for a third party to want to weigh in. When I have litigated in front of the federal circuits, I often have third parties file these amicus briefs, either in support of my arguments or against my arguments, because they might be affected by it. An amicus brief is a very unusual thing in a trial court, because generally nobody cares except the parties who are actually in trial. But court has inherent power to ask for these amicus briefs, and Judge Sullivan here has done so. He apparently wants additional opinions or briefs to be filed about this particular situation. There are multiple ways of spinning this, but the most likely situation is that the judge is showing his displeasure with the DOJ's position, that because there's no one arguing for the continued prosecution of Michael Flynn, he wants a third perspective to be able to understand countervailing issues. And, given the unprecedented nature of this motion to dismiss, it's not crazy to want someone else going to bat for the prosecution of Michael Flynn. Typically, though, the federal judge usually accedes to the request of the DOJ prosecutors. If the DOJ doesn't want to move forward with the prosecution of an individual, generally there's no reason why the judge would not agree with that position. But obviously, for reasons that we have already discussed, this is not a usual situation, and nothing is really normal in the motion to dismiss that the DOJ has filed. Now, after Judge Sullivan asked for these amicus briefs, that's when it really got real. He issued another order a few days later in which Judge Sullivan has asked for a magistrate judge to be appointed to basically present an opposition to the DOJ's motion. The order seeks to appoint Judge Gleeson, who is a former federal prosecutor and former federal judge, and that judge is going to basically make the arguments that the DOJ is not making in moving forward with Michael Flynn. And on top of that, and here's where things really get interesting, Magistrate Judge Gleeson is going to decide if Michael Flynn has committed criminal contempt by perjuring himself. So let's take a step back here, because this is pretty unprecedented. What is a magistrate? Well, a magistrate judge is sort of an ad hoc helper of the court. So the federal judges are all appointed by the President of the United States, and they often deal with situations that are either too complex or too time-consuming to deal with themselves, or they want a neutral third-party view on a particular issue. So you would create what's called a magistrate judge, which is sort of an ad hoc position. I've run into magistrate judges a lot because often judges don't want to have to deal with discovery, literally millions of pages of documents. And so they hand that off to a magistrate. Sometimes the magistrate is a former federal judge, a retired federal judge, and sometimes it is a lawyer who wants to eventually become a judge. So they sort of get their training wheels by becoming a magistrate. In this particular case, Judge Gleeson is a former federal judge, retired, but he's also a former federal prosecutor. And here, Judge Gleeson is sort of wearing two hats. On the one hand, the first part of the order requires Judge Gleeson to be an advocate, to oppose the DOJ's motion. And the second half of the order is effectively to be a neutral third party and make an independent decision as to whether Michael Flynn has committed criminal contempt and perjured himself. Now, what's going to happen here is absolutely anyone's guess, and we don't really know what to expect other than the fact that this question of whether Flynn committed criminal contempt by perjury is separate from his 1001 guilty plea of lying to federal officials. So really, it can only be in connection with the representations that Flynn has made to the court. And of course, that is what criminal contempt is for. It's the inherent power of the judge to punish people for shenanigans that happen in front of them. Now, of course, the DOJ dismissing a case after a guilty plea is extraordinarily rare, to the point that I've never heard of it happening. But the judge appointing a magistrate to oppose such a motion is just uncharted territory in general. Obviously, some people are going to argue that this is yet more evidence of the deep state railroading Michael Flynn, and some are going to argue that this is simply an independent judge standing up to a clearly inferior motion by the Department of Justice. But as with the request for third-party briefing, this really signals that Judge Sullivan does not want to give in to the Department of Justice. He still might, but he's obviously going to put the DOJ through the ringer before they get there. And in fact, Sullivan has actually done this before with the prosecution of Ted Stevens. So who knows what Judge Sullivan is ultimately going to do here. And not that the deep state theory has any merit, but this may be in fact a bit of a whipsaw, that Judge Sullivan is taking out a stick to try to get Michael Flynn to do things the easy way instead of the hard way. Judge Sullivan might be showing that things can in fact get worse, that there's the possibility of yet more jail time associated with criminal contempt, so it would behoove him to simply move forward with the easy thing of the guilty plea instead of making a ruckus and potentially finding more jail time. So it might be a reason to persuade Michael Flynn to back down from these shenanigans and also try to get the DOJ to back down. Things can get worse before they get better for them. But I'd say that the DOJ has already been embarrassed by this whole episode, and it seems like things are going to get worse before they get better. But ultimately here, and this is great advice for young lawyers, old lawyers, pretty much anyone that may ever show up in federal court, do not mess with federal judges. They will make you regret that. So it's anyone's guess what may happen next. But this motion from the Department of Justice is starting to create a pattern from Bill Barr's DOJ. The DOJ is emboldened. It's suddenly contradicting earlier prosecutorial decisions without any rationale or changed circumstances, and career DOJ employees are resigning rather than sign the pleadings. Only Tim Shea signed the motion to dismiss, and even then he did it with the wrong bar number. And given the speculation about a presidential pardon, it really appears that this is a backdoor pardon by the Department of Justice, that instead of making President Trump take the fallout from actually pardoning a sentenced and convicted Michael Flynn, they're not even going to get to that stage by dismissing the investigation entirely without even getting to sentencing. So it was like the plea never happened. At the end of the day, Flynn made phone calls to the Russian ambassador and then lied about them. That's why he was fired by the Trump administration. And apparently everyone from the NSA to the GRU was listening to those phone calls. But the real travesty is how much money that call probably cost Flynn. He could have saved so much money on his cell phone bill with Ting Mobile. And, you know, if you're going to commit treason, you might as well do it as affordably as possible. And with Ting Mobile's LTE network, your calls to Moscow will be super clear. Ting Mobile is a different kind of mobile provider. With Ting, you only pay for the actual data and services that you use at the end of the month. And because you're paying for what you actually use, Ting customers pay on average just $23 per month for one device. And Ting provides you with great LTE coverage because it uses the T-Mobile, Sprint, and Verizon network. So now you get the benefit of all three of these massive networks wherever you go. And with Ting, you can use almost any cell phone, including the newest iPhones and Pixel phones, and you can use the same phone number that you're using right now. There's no contract, no overage fees, and no carrier tricks. You just pay a fair price for the talk, text, and data that you use up every month. And Ting has award-winning customer service because they don't have any brick and mortar stores. Not that you would go to a brick and mortar store right now anyway. So they pour their resources into phone support. If you have an issue, you can give them a call, you can send them a text, or you can go on social media or Discord. And Ting is great, especially if you're on Wi-Fi all the time, which of course most of us are. Our houses have Wi-Fi, because you'll end up paying way, way less than you do now because you don't need to use a cellular network. You can just use the Wi-Fi network that you're on anyway. So, some people should pay $200 a month for unlimited data if they're outside of the home. But if you're surrounded by Wi-Fi all day at home or at work, you might be paying hundreds of dollars more per month completely unnecessarily. Ting gives you the option to pay for only what you use. So if you go to LegalEagle.ting.com, you can use your last bill to compare just how much you would save. And Legal Eagles will get a $25 credit by going to LegalEagle.ting.com, and that could cover your entire first month of service. And since there are no contracts, you can try it for a month, no strings attached. Again, all you have to do is click on the link in the description or go to LegalEagle.ting.com to get a $25 service credit for whatever you want. And of course, clicking on the link in the description really helps out this channel. And check out this other playlist of all my other real law reviews where I tackle legal news of the day, including quarantines and craziness going on at the DOJ. So just click on this playlist and I'll see you in court.